Good evening once again. The meeting of the Rent Control Board is hereby called back to order after its closed session. My name is Naomi Sultan. I'm Vice Chair of the Rent Board, leading the meeting tonight in place of Chair Nicole Phillips, who can't be with us. Anyone wishing to address the board on a specific item on tonight's agenda should have contacted our board secretary prior to the meeting. We will recognize the speakers and arrange to have them speak when it is their turn in the queue. The first item on the agenda is the report of the closed session. Would the General Counsel please report on the closed session?
Board convened in closed session at 6:34 to discuss one item of pending or prospective litigation and adjourned from closed session at 7:12 p.m. with no reportable action taken. Thank you.
Thank you, Mr. Lewis. Now moving on to approval of the minutes. May I have a motion to approve the minutes of the board's last meeting?
I reviewed. Oh, go ahead, Steve.
I reviewed and I moved that we approve the minutes as written.
Excellent. We have a motion from Commissioner Duran. Do we have a second?
Second.
Second from Commissioner Foster. Would the Secretary take a vote, please?
Commissioner Foster?
Yes.
Commissioner Duran?
Yes.
Commissioner Trosis?
Yes.
And Vice Chair Sultan?
Yes.
Motion carries.
Thank you. Moving on to special agenda items. Do we have any announcements tonight?
Yes, we do. I have just one announcement or information item. I just wanted to mention that the city's eviction moratorium for people who have been impacted by COVID-19 remains in effect until September 30th. And as we will hear later from Mr. Augusta when he gives his report, the state law has an interaction with that, and the city has produced a information sheet related to the interaction of the two, and that information sheet is available on our website, and we will also mail that out to anybody who calls our office and requests that. So that's the announcement I have this evening.
I have a quick question.
Commissioner Charlton?
Sorry. Just on that item, did we contemplate emailing our listserv? I'm just very concerned that it's very confusing for many people right now with all of the superseding. Well, I mean, theoretically, the state law would be superseding, but I think there's different eviction moratoria depending on the jurisdiction. Can we consider emailing that out to everyone?
Yes, we will distribute it. The city is also distributing it widely and doing social media on it, but we can send it out to our email list as well.
Great. Like for example, I put it on my personal commissioner Facebook page. I think people definitely had questions. I just feel like the more information, the better, because it's quite confusing. Thanks.
Thank you. Commissioner Foster?
Yeah, last night at a club meeting, there was a slide presentation that had a very nice slide containing what the city attorney's dissemination of the exact impact of state and federal law on Santa Monica's individual situation with a calendar is posted as well. And I've also shared that on social media and things like that, and circulated it to some clubs. We just need to get that out as widely as possible. And I mean, they picked it apart. So it's a really, really solid summary of how it affects Santa Monica.
Commissioner Foster, are you aware if the city attorney is planning a video, to create a video presentation to help people understand this complicated new state law and how it interacts with our local moratorium, which I understand is also soon to expire?
I have heard talk of presentations to come, and I think clubs are also, private clubs are also contemplating public information sessions.
Okay.
Nothing definitive.
It's going to be very important. Okay. Excellent. Well, thank you. I'm glad we're getting the word out on that. There's a lot to learn in the coming days. Okay, I think we're ready to move on to jurisdictional items, unless there's any more announcements or thoughts. Okay.
I have a comment. There's no public comment, right?
Oh, did I skip? Oh, I skipped public comment. I do believe there, has anybody requested to give a public comment?
No, there's no general public comment.
Okay.
So in that case, Vice Chair Sultan, for the jurisdictional items on 10A, 1 and 2, I read both of them. I think they're pretty straightforward. I'm definitely prepared to make a motion if that's something that my other commissioners would entertain.
I would entertain such a motion.
Okay, so I would move to grant the owner occupancy exemption 10A, 1 and 2. Do I need to read that out for the record? I don't know. In any event, I move to grant them. I guess, Stephen, do I need to say the names of the cases? No. Okay, great. Well, that's my motion.
Do you have a second? Excellent. Second, we have a motion from Commissioner Foster. We have a second. Motion from Commissioner Trosa, second from Commissioner Foster. May we, is it time to take a vote?
Yes.
Okay, excellent.
All right.
I'm great at this, guys.
Commissioner Duran,
Yes.
Commissioner Trosas,
Yes.
Commissioner Foster,
Yes.
and Vice Chair Sultan.
Yes.
Motion carries.
Excellent. So moving on to the appeal on our agenda, which is item, U-01388. Let's see, 1647 Oceanfront Walk, Unit 4, SBZ LP by R. Zuri. May we have a staff report on this item?
Good evening, Commissioners. SPZLP, who's the owner of this property, is represented in this matter by partner Robert Zahuri, began construction in 2 vacant units on this property, units 9 and 16, around October 15th of 2019. He obtained a permit for renovation of the kitchen and bathroom in these units. Charles Hicks, who's the tenant in Unit 4, filed for a rent decrease from multiple impacts from the construction that ensued. Mr. Hicks testified that he's being treated for stage 4 cancer, which requires him to be home sleeping and resting, and the impacts from the project have been significant. The hearing officer granted him decreases for 2 impacts, noise and dust. Mr. Zahuri has appealed those decreases. He argues that because the building department approved the means and method plan submitted with the permit application, Mr. Hicks is precluded from seeking rent decrease from the impacts of the construction because he failed to challenge that plan, and the city's approval had a res judicata effect on the findings contained within it. He argues that the board may not grant a construction decrease in this case because the building department never cited the landlord for a violation of the building code. And he contends that the hearing officer erred because in granting the decreases, she applied the standards for construction decreases from upgrades, whereas the construction here was for necessary repairs to an aging building. And finally, he argues that the record does not support the hearing officer's finding that the impacts from the construction lasted 172 days, basically from October of 2019 to April of 2020. Res judicata refers to the preclusive effect of a final judgment on the merits, thus to prevent the relitigation of the same claims in a second suit between the parties. There's a related concept, collateral estoppel, which precludes the relitigation of issues argued and decided in prior proceedings. Neither of those concepts apply here. The building department does require a means and method plan before it approves a building permit. The plan discloses the means and methods of how construction will be performed to inform tenants of potential impacts to the habitability of their units and steps the owner intends to take to mitigate those impacts and whether those impacts will require them to be temporarily relocated. The building department does not approve plans through a process involving litigation. At most, in approving a plan, building staff find that it has adequately informed tenants of potential impacts, mitigation measures, and possible temporary relocation. Nothing in the municipal code that instituted this requirement precludes a tenant from petitioning the rent board to adjust his or her rent because of substantial impacts from the construction that followed that permit. As to Mr. Zahuri's next argument, that the building department never cited him for violations of the building code, this does not preclude the board from granting him a decrease. The building department has the authority to cite an owner for violations of the building code. The rent board has the authority to regulate rents to ensure their fairness. When substantial impacts from construction make the rent unfair, the board has the authority to adjust the rent. When it does so, it is not infringing on the authority of another agency, it is fulfilling the very purpose of the law that established the board. The Court of Appeal rejected the argument that the board lacked the authority to grant decreases based on local health and safety laws because those laws are enforced by other agencies, in the case Sterling v. Santa Monica Rent Control Board. The court held that the lawful purpose of the rent control law was to eliminate excessive rents while providing landlords with a fair return on their investment. When the board decreases rents for violations of health and safety laws, for substantial deterioration of a rental unit, or for reductions in services, it is adjusting rents that had become excessive. Here, the hearing officer found just that the impacts from this construction had made the rent excessive. Mr. Zahuri argues that the hearing officer used the wrong standard in determining whether to grant a decrease, that he should have used that she should have used the more restrictive standards for necessary repairs and not the standards used in this case, which is for upgrades. But the permit for this project said it was for removal and replacement of the toilet and bathroom sink, retiling of the showers, and removal and replacement of the kitchen sink and cabinets in 2 vacant units. A photo of the units during construction showed the walls and floors stripped down to the studs and ceiling joints exposed. During this project, there was an emergency plumbing repair that was completed separately in a few days, but the renovation of vacant units started in October 2019 and was still not completed at the hearing date in March 2020. The hearing officer reasonably concluded from this evidence that the work being undertaken was not for the repair of any item, but for renovation and upgrade of the units. That meant that Mr. Hicks was entitled to a rent decrease if impacts from the construction substantially reduced any housing services or substantially interfered with his ability to occupy his unit as a residence. Though the board reviews this matter as an appellate body, it may reverse that finding only if the hearing officer's finding was clearly erroneous and wholly unreasonable given the evidence. The record, however, reasonably supports the hearing officer's finding that this project was for upgrading of the units and not for merely their repair of items in those units. Finally, Mr. Zahuri argues that the record doesn't support the hearing officer's finding of the duration of the impact of noise and dust. The parties all agree that the construction started around October 15, 2019. Mr. Hicks testified that the workers took months to tear up the vacant units, and while they were doing so, it sounded like a constant booming in his apartment. The noise continued after the demolition with drilling, hammering, and banging, even by the date of the hearing in March 2020. Mr. Zahuri testified that the noise was audible only during the first 3 days of heavy demolition in October of 2019, and he attributed any other construction noise to the construction in the adjacent property. Mr. Zahuri's own construction timeline, which he submitted into the record, however, showed the demolition phase to have lasted through December 10th of 2019. Code Enforcement Officer Jones visited the property on December 5th and 10th, 2019. She confirmed construction noise audible from the higher floors of this building and banging and loud conversation between workers while she was passing the stairwell just outside of Mr. Hicks's apartment. She was in his apartment for a few minutes, and during that brief time, she testified that she did not hear any construction. But board investigator Daniela Wodnicki, who visited the property on February 19, 2020, when construction had stopped for that day, said that she did hear construction noise from the other property. But because construction had stopped that day, she came back the next day when construction had resumed on the property at issue, and she heard drilling, banging, and loud conversation between workers from the hallway and stairwell outside of Mr. Hicks's apartment, and even from inside the apartment. Because the records showed that the construction still had not finished by the March hearing and had a few more weeks estimated until its conclusion, the hearing officer reasonably found the noise impacts to have lasted from October 2019 to April 3, 2020. As to the dust impacts, Mr. Hicks testified that dust was prevalent and heavy in the air since constructions began in October 2019, and sometimes it was thick like a mushroom cloud. Fearful of infections because of his cancer treatments, he was forced to keep his doors and windows shut and forego fresh air to avoid the dust from entering his apartment. He said the owner failed to mitigate the dust impact, no air filters, plastic containment areas, or any similar equipment outside the 2 vacant units. He only had a cleaning crew mop the hallway floors once a week. Mr. Hicks submitted photos of construction crew dumping loose particulate debris into a garbage bin from the second-story window of one of the 2 vacant units, obviously causing dust from that. Code Enforcement Officer Jones did not recall an accumulation of dust in the hallways during her December visit, but Ms. Wodnicki did observe a significant amount of dust and debris in the common area stairwells, hallways, and caked on windowsills during both her visits in February of 2020. Characterized the air as stagnant with dust lingering and heavy in the air just outside Mr. Hicks's apartment. She observed dust and debris on each step leading from the second floor and to the third. She did not see any equipment used to capture or filter the dust on either day that she visited. Mr. Zuhuri testified that he had instructed workers to mop the floors at the end of each day and to bag up major debris, and he submitted photos of that. He attributed the dust Ms. Wodnicki saw to an emergency pipe repair in one particular unit at that time during her visit. That repair was not part of this larger renovation project. But Ms. Wodnicki's observation and video document the pervasiveness of dust and debris throughout the building, not just outside one unit, and not what one would expect if floors are mopped every day. The hearing officer concluded that the dust and debris impact had started in October 2019, was ongoing, and would cease only after the construction was estimated to end at the start of April 2020. Because that conclusion is a reasonable one given the evidence, the board should affirm and this decision.
Thank you for that report. Does anybody have any questions? All right. It sounds like does anybody want to make a motion, or shall we begin?
We actually have a speaker.
Ooh, a speaker.
Me?
We have a speaker on this item. I'm actually unclear who the speaker is.
It is the owner representative, Vano Abazadze, I believe it is.
Excellent. Is he ready to speak?
Yes.
Good evening, board members. My name is, can you hear me? Oh, I apologize. My name is Vano Abazadze. I'm a representative of the owner of the property at 1647 Oceanfront Park. So I would like to address 2 points that I think are dispositive in this matter. Can you hear me?
Yes, we can. Thank you.
Yes, thank you. I apologize. Yeah, two points I would like to address. I think the staff report covers most of the factual findings, but I think the argument that is dispositive here is the fact that the building was built in 1911. It's more than 100 years old. The building suffered damage from corrosion, moisture-related decay, and termite damage. We, at the administrative hearing stage, we introduced all the evidence showing why these repairs were warranted. The standard applicable here is set forth by the Court of Appeal in Golden Getaway case that says that the housing provider is allowed to undertake reasonably necessary repairs. And we proved that point, I think, at the hearing stage by showing pictures of mold-like conditions of the cabinets on the floors. My client, Mr. Zahouri, testified that there were plumbing issues, and actually investigator from the rent board observed the emergency that were going. It's the pipe burst, and this was contributed to the dust accumulation. So in addition to that, there was a wiring problem because it wasn't up to code. I'm explaining this because to give you a visual of the conditions of the property, to explain why we had to undertake that renovation. And I think the hearing officer, and we explain in our appeal letter, the hearing officer misapplied the standard, which is not necessary. It's a reasonably necessary repairs. Also, I would like to bring your attention to the fact that there were contradictory testimonies from investigators, one from the Code Enforcement Division and another one from the Rent Board Division. And hearing officer, without any explanation, gave deference to the Rent Board investigator, even though, to my understanding, we submitted proof that the Code Enforcement investigator was correct in her findings when she didn't observe any dusty or noise-related condition inside petitioner's unit. And the important thing here is that there was ongoing construction in adjacent property next to the building where petitioner's windows face, and that's the reason. Actually, Rent Board investigator observed those conditions as well. She considered to the fact that the banging noise were stemming from the adjacent property. They were doing exterior renovation as well. So I submit that the findings of the hearing officer were in contravention with the evidence submitted before her, and also the petitioner never satisfied his burden of proof. All the allegations made during the administrative hearing were based on his testimonies and observation. No hard evidence were introduced, and no video recordings, no pictures. On the other hand, my client introduced and property managing representative testified to that they employed utmost care in maintaining and mitigating any adverse impacts during the construction. Therefore, I think the hearing officer decision is clearly erroneous and unreasonable, and I submit.
Thank you for your statement. Do any commissioners have questions for our speaker? Guess not. Well, thank you very much. I believe we will move on to deliberation at this juncture.
I have a question maybe for Lonnie. So the tenant did not choose to speak here tonight on the situation?
Yes, he responded that he did not want to speak.
Got it. Okay. I mean, I'm prepared to start discussion, Vice Chair Sultan, if that's okay. I just would state that, I found the staff report to be compelling. I think, I've been a pretty strong supporter of ensuring that the means and methods plans are very fully incorporated, especially at the beginning of any construction, that everything is safe and that we are protecting our tenants as they're undergoing, significant construction related noise, pollution, etc. Of course, very sympathetic to the fact that this individual tenant is suffering from health related issues, although that is not necessarily relevant to my thought process here. I don't find the appellant's argument to be very compelling, and I actually read the underlying information, not only in the staff report, but then in the hearing officer's decision. And I think that, it's pretty clear to me at this point, but I'm happy to hear from fellow commissioners.
Commissioner Foster?
Thank you. And I've got a clarifying question for staff that I thought of. And I wanted to just, I have similar feelings to Commissioner Terosas already made, but I think it's worth noting for the public, as part of this means and methods plan, if the scope of the work is defined by the permits that were applied for, then the means and methods plan was laid out for the time and scope of those permits. But regardless of what the code enforcement officer found at an earlier time, at a subsequent time, a couple months later, our own investigator found much more extensive work being done in the units than was applied for in the permits. Is that correct? Ceilings being laid bare, walls down to the studs, isn't just kitchen and bathroom, is it?
It's the ceilings being laid bare and the walls down to the studs were depicted in photographs submitted by Mr. Hicks. And that was during the demolition part. Apparently, the code enforcement officer who testified visited twice, either after or at the very end of that demolition process, and he wasn't necessarily there to assess impacts from construction such as that are raised in this petition here. She was likely there as part of the permit approval process and inspection process. She saw what she saw, and she recalled what she recalled, and she testified to that in March. In February, and that was in December of 2019, in February of 2020, when the investigator went out, she went out specifically to look and assess for the impacts of the construction that were alleged in the petition at the request of the hearing officer. And so not only did she spend more time there, but she was there specifically to check it out. She looked and she went through several floors, and she was checking to see whether there was dust, how it was being mitigated, if there was noise, if the noise was being heard inside. And that's what she testified to at the hearing, and that's part of the record that was relied upon by the hearing officer in making her decision.
Thank you. Thank you for that clarification. And I also, I'm with Commissioner Terosas. The staff report is clear. And even if the rent board members as individuals disagreed or could have reached a different conclusion, that's not what we're being asked to do. As an appellate body on this matter, we're being asked to decide if the hearing officer should have come to some other reasonable conclusion other than this one. And I don't see any way that standard is met. And I'm ready to move on this.
Thank you, Commissioner Foster. Commissioner Duran?
Yes, thank you. I would like to add on that we're here to see if it's a clearly erroneous standard in what the hearing officer's decision was. And based on I don't believe that there's sufficient argument to be said that they misapplied the standard as to the necessary repairs based on the Golden Gateway case. I think that the facts show that the hearing officer made a reasonable conclusion, and regardless of whether any of us as individuals would agree with it or not agree with it, I don't think it was an unreasonable decision that could result in a clearly erroneous decision that would enable us to reverse it. So I think based on the law, based on the facts that were presented in the hearings, I'm ready to move forward with affirming the hearing officer's decision.
Is that a motion?
Yeah.
Still the motion.
Oh, sure. I move that we affirm the hearing officer's decision with the conclusions of, say it for me, please. The conclusions of law and the statements of facts.
Adopt the findings of fact and conclusions of law.
That's it. I will never, ever get that, ever. But that's what I would like to include as part of my motion.
I'll second.
Okay.
Excellent. May we take a vote?
Yes, Commissioner Foster,
Yes.
Commissioner Drumm,
Yes.
Commissioner Terosis,
Yes.
and Vice Chair Sultan.
Yes.
Motion carries.
So I believe that is the end of the jurisdictional items, and the next item on our agenda is administrative items, and that includes staff reports. I believe the first staff report is from Mr. Augusta. So if you are present, oh, excellent, there you are.
Hello.
Hi. Welcome.
Thank you. Would you like me to start, Madam Chair?
Yes, I would. Thank you, sir.
Good evening, commissioners and staff and the public. I'm Brian Augusta, the board's legislative advocate up in Sacramento. And tonight I'm going to talk a little bit about the very, very strange year that we had in Sacramento. And as will be clear when I get to the substance of this, our usual report at this time of the year, I would walk through quite a few bills with you all, some of which the board had taken positions on, some that you all have just been following and talk about the outcome. But the reality is that this year, there are really no pieces of legislation worth, I think, taking the board's time to talk about other than 3088, which we will talk about in a moment. And just to talk a little bit about why that is, as you all know, commissioners, as elected officials trying to conduct your business and maintain the democratic process in the strange circumstances that we're in this COVID-19 pandemic, you multiply that by however many numbers to get to 120 members who are all representing the state of California in an enterprise that's used to daily interaction between members of the public and elected officials, that now is all being conducted remotely. It really just sort of changed the circumstances for policymaking. And I think the most telling sort of statistic in that regard is that last year, at this time of year, by our estimate, there were about 1,000 bills that made it to the governor's desk. And this year, there are only about 400. And I think that 400 number is even remarkable. In addition to that, as those of you who are watching closely in Sacramento know, in part as a result of some of the COVID-related impacts to the way in which both houses were able to conduct their business, which included that some Republican members were required to, of the Senate, were required to attend the floor sessions remotely and vote remotely. That greatly slowed down the work of both houses, or particularly of the Senate. And then when you add to that the usual end of session sort of things that go on between the houses and between all parties, there was a somewhat remarkable outcome, which is that a number of bills, some of which were priority bills for the Senate leadership, were passed by the Senate earlier in the year, moved over to the Assembly, passed off the Assembly floor on the last night of session, but sent back to the Senate for concurrence, which is the usual process if a bill had been amended in the second house, then the original house has to take a concurrence vote on the floor. Those bills, many came back too late for the Senate to act. And so a number of bills, including key bills that some of you have been watching either as commissioners or in your private capacity related to sort of housing production, all died without ever getting, not because they didn't have the votes, but because the process did not allow enough time for those bills to be heard. So I think that's a really kind of puts an exclamation point on a very strange year and a very difficult year, in which I think everyone was very much focused on COVID-19 and the economic impacts that that's having for all sectors, but for the housing market and for renters and for small landlords. And I think also some attention to other issues that are really front of mind right now for a lot of folks, including disaster and wildfires. But the capacity to carry out some of that policymaking was greatly diminished. And even the normal give and take on a bill like 3088, where it's all being conducted remotely, added to the challenges there and the outcomes there. So I think that sort of sets the stage for where I want to focus my remarks tonight, which is to provide a bit of a summary about AB 3088, the policy behind it, and how that came to be, both what's in there and what's not in there. And I'm not going to attempt to provide a definitive explanation of the interaction between that and your local ordinance or the CDC's recent order. I'll leave that to your counsel and to the city attorney, but I will talk a little bit about what the potential implications are on some of these moving parts, because I know that that's very important to you all and to the members of the public who may be watching as well. Tracing the history of AB 3088, the details of which I'll talk about in a second, as it became clear that the impacts of the economic fallout from the pandemic were going to have a huge impact on the ability of many renters to pay the rent, and similarly on the impact of many landlords who are relying on that rent. It became a very urgent topic of conversation. And the first, probably most important event that occurred, in addition to 2 executive orders that the governor issued, which provided probably the most significant thing that came of those orders was the authority to local governments to enact some local protections, which many did. But the more important piece was the rule of court. And that rule, as you all know, has put essentially a pause on evictions until originally it was either until the rule was repealed, which I think none of us really anticipated it being repealed quickly, or the end of the emergency order, the executive order, overarching order related to the pandemic, plus 90 days. So I think many people were working on the assumption that those protections, which have stopped most evictions from moving forward, would be in place for some time to come. However, as a result of a number of factors, including litigation over the rule, the Judicial Council made the decision to repeal the rule effective September 1st. And there had been an earlier effort to repeal it, which through some advocacy from a number of sectors, including the governor's office and from advocates like myself, we helped to ensure that they didn't repeal the rule before the legislature had an opportunity to act and replace it in some manner. But that rule has now sunset, and technically the protections that it provided, which were essentially a limitation on the issuance of a summons in an unlawful detainer, that has been lifted, except with one exception, the 3088 addresses, which I'll talk about. So that was the looming crisis that we were all, I think, concerned about, was what will happen once this rule is repealed, and particularly with respect to those who, because of COVID-related impacts, have not been able to pay the rent. There were 2 bills in the legislature both of which did not ultimately move forward that addressed this. Actually, I should say there were a couple of other bills that one related to mobile homes that did move forward, and then a couple of other entries in the conversation. But the main two bills were AB 1410, which would have provided a tax credit and some financial relief to landlords, along with a process by which tenants could make up the unpaid rent over a 10-year period through an agreement with the state. And that bill got held in the Appropriations Committee in the Assembly. The other bill, AB 1436, which was sponsored by a number of tenant advocacy groups and others, would have provided protections that would have made it the non-payment of rent could not be the basis for an eviction through at least April 1st of 2021. So in other words, any unpaid rent accrued to that point could never be the basis of eviction, and then gave the additional time period for tenants to repay that rent. With those two bills out there, the governor's office eventually entered into the conversation as well and offered a few different proposals around what might be a middle ground, if you will, between those bills. And one of the messages that I think is fairly clear from the outcome of AB 3088 is that the state of California, with a budget deficit of several $billion, is not in a position to provide the financial relief, and that many are looking to the federal government to do so, which we know is an ongoing conversation at the federal level. And so AB 3088, I think, is a product of that in many ways, in that it became clear that there wasn't probably going to be some financial assistance at the state level. And so the conversation really shifted to providing some eviction protections, at least until next year, when we all collectively have a better sense of what the feds are planning to do, if anything, with respect to financial relief, right? 3088 took some of the concepts of 1436 in principle that we're going to make unpaid rent or protect tenants from eviction for a non-payment of rent, and essentially convert that unpaid rent to a civil debt that could be collected later but could never be the basis for eviction. And that was the governor's proposal that eventually was put into 3088. Now, it faced two important hurdles. One was that by the time that became sort of a public conversation, we were up against some really tight deadlines in terms of the end of session. And it was clearly a cliff for everyone involved, because we knew the rule of court was going to expire September 1st. And we knew if the legislature did not act by the end of August, the opportunity to do anything legislatively would probably be foreclosed. The other thing is we needed the bill to take effect immediately. So that means a 2/3 vote of both houses and an urgency clause, which increased the level of difficulty for passing the bill and made it almost essential that the bill be some form of compromise that both landlords and tenant groups could live with. And so all of those factors, I think, explain a bit what 3088 is and isn't with respect to eviction protection. So let's talk quickly about what it does. AB 3088 has a number of provisions, but the key element of it is dealing with non-payment of rent. And what it says is that for rent that accrued between March 1st and August 31st of this year, well, first let me say that what we typically think of as a 3-day notice to pay rent or quit is now expanded to a 15-day notice. And so for any non-payment of rent that arises beginning March 1st through January 31st, a 15-day notice is required. 3-day notice is no longer the term, it's a 15-day notice. For the rent that is accrued March 1st to August 31st, if a tenant receives that notice, 15-day notice demanding rent, they can attest that they have some COVID-related impact that is made it has impacted their ability to pay that rent. They provide the signed declaration that is required. If they provide that to the landlord for that time period, so this is all rent that would have been accrued in the past by the time the bill became law, that rent, if they provide that declaration, can never be the basis for eviction. Can be the basis for a civil lawsuit later to collect the unpaid rent, but not eviction. Second tier is rent from September 1st through February 1st or January 31st. And for that time period, any unpaid rent, same notice requirements, same declaration required of the tenant, and the tenant must sign the declaration and return it each month that they're served with such a notice. If they do that, the tenant cannot be evicted for that non-payment, provided that they tender at least 25% of the rent that is owed. Now, what the bill provides is that for that 25% requirement, which could be 1 month or could be several months in that time period, the tenant need only pay that amount, whatever amount is required over that several months, by January 31st. If they pay that, if they return the declaration in a timely manner in that 15-day period and tender the rent, pay the rent to the landlord, 25% by January 31st, they're protected from eviction for forever for that non-payment. Now, again, that other 75% can be collected in an unlawful detainer. There is one wrinkle that I want to make sure folks know, which is no documentation, additional documentation other than the declaration is required of the tenant except tenants who are higher income. Now, higher income is defined in the bill as 130% for your jurisdiction of LA County's median family income. So a tenant whose income exceeds that and the landlord has evidence in their possession at the time that they're serving the notice that the tenant is higher income, perhaps from documentation that was provided when they leased up the rental unit, they can ask for additional documentation. And that is just a requirement to provide the documentation. It doesn't provide an additional test about the sufficiency of the documentation, but those higher income tenants can be asked for more documentation about their COVID-related income loss. So that takes us to the two, I think, most difficult pieces of this. One is the question of how it interacts with local ordinances. And, this was an issue that I think was probably a very contentious issue on sort of both sides, both for landlord groups and for tenant groups. The resulting policy essentially protects all ordinances that existed as of August 19th. Nothing in those ordinances is preempted by what's in 3088. However, with respect to rent-related provisions that expire after August 19th, the bill does limit the authority to renew those or extend them or amend them. But it also preserves the authority of local governments to enact other additional protections. So, for example, the no-fault provisions in Santa Monica's ordinance, the city has continued authority to continue to regulate that and other for-cause evictions, anything that they could regulate through their police powers as part of the establishing the basis for just cause for eviction. Those are not in any way implicated by 3088. The last piece that I want to highlight is what it doesn't do, which is it does not really address Rule 1. The only piece that it provides with respect to a moratorium that replaces Rule 1 is an extension for non-payment cases until October 5th. So until October 5th, those non-payment cases cannot move forward. But all other cases, the rule expired and this does not replace it. So those cases or cause notices, for example, could proceed as of September 1st or 2nd when the rule was repealed. And this bill not replace that rule. And that has been, I think, the most controversial piece of this in many ways is that it leaves many families at risk of eviction during a pandemic, in which we know that of course, not only is it important that folks stay housed for a variety of reasons, both related to and unrelated to the pandemic, but at a crisis time when kids are learning from home and all of the other impacts that this has placed on stress that is placed on households. So, just watching from Sacramento, there's clearly, I think, a push going on to extend some protections there. And I think over the next few months, we will, I think we'll have a better sense of what the implications of not extending Rule 1 will have on our communities and on the courts as evictions ramp back up. Let me just briefly say, too, that shortly after the governor signed this bill, which he did the night it passed, which was on the last time of session, and it took effect immediately, shortly thereafter, the CDC, as many people are aware, issued its own federal rule that applies nationwide, that provides some additional moratorium on non-payment eviction cases. Now, the interaction between that order, this state law, and local protections is, I think, an ongoing conversation that many are analyzing, and that will probably be an ongoing conversation for a while. But one fundamental issue is the order provides some statement that that order applies unless there's a more protective state law. So obviously part of the conversation here is 3088 a more protective state law? And there clearly are some provisions which I think most would agree are more protective, and there are some instances where it does not provide protections that which the CDC order could provide protection. So that's going to be an ongoing, I think, conversation over the next few weeks about the scope of that order in California. So I think that's something that I'm sure your staff and the city attorney's office will be closely monitoring and developing a response on. And we will obviously be watching that here at the state level, including whether the AG or the governor's office weighs in on the question. So with that long tracing of 3088, let me stop there, Madam Chair and Commissioners, and see if there's any questions or comments on what I've presented so far.
Commissioner Foster?
So a Santa Monica City Attorney summary of how 3088 and the CDC's decision apply specifically to Santa Monica has been issued, and it's been gone over with a fine-tooth comb by all different sorts of groups that have a stake, and has been publicized. But one of the things it finishes up with by saying is that when the legislature reconvenes in January,
right,
or they'll do something else. So I think, as complex as it is, I think we understand what 3088 did. But what sense do you get of what comes next?
Yeah, thank you for that.
If Biden's elected, maybe one thing. If Trump, I'm not even going to say it. But yeah, what do you think could happen?
Yeah, thank you for that. I started to comment on that earlier and moved off the point, but I think one of the, as you just alluded to, I think one question is sort of, will there be some relief from the feds? And obviously the outcome of the November election may or may not change that, but I think many are hoping that we'll get some sense of that before November. But regardless of what the feds do or don't do, I think all parties understood that this bill, 3088, was in many ways a stopgap, with the sort of the shot clock running out, and the session wrapping up, that we needed to put something in place. But all parties acknowledged that with it ending in January, and we clearly will not be out of this economic or public health crisis at that point, we're going to have to, part of the reason it was pushed into January was to make sure it didn't expire while the legislature was out of session. So they will be back in session. in January, and as early as the one date in December when the legislature reconvenes to swear in new members and do some other business, a bill can be introduced, and I think many are seeing that as a target date for 3088 version 2 to be at least in the hopper. But without question, in January there will be a mad dash to enact something to replace it, because it will otherwise expire at the end of January with nothing in its place.
I know that landlord associations are a big part of this conversation regarding any possible legislation, but we've talked about the tenant side of this almost the entire time, which is totally, obvious reasons why in a pandemic and in an economic sense. But what about the landlords? What are you hearing from them as to their concerns for a follow-up measure to 3088, and what some of them may need from a bill like this in order to stay solvent?
Yeah, I think that's a very good question. And one of the other pieces that did not really get addressed in this legislative session is some relief for mortgage holders. The bill provides some, I think, somewhat superficial provisions in that regard. So that's one piece. But unquestionably, if it's as bad as many of us suspect it is with respect to the ability of many, particularly lower wage workers, to make the rent, we know that part of the answer has got to be some financial support for small landlords or for tenants directly, whichever makes the most policy sense. It's definitely a question, Commissioner Foster, of money, and I think that's why folks are hoping to kind of put this stopgap measure in place until we know better what the feds are doing. And if the feds aren't doing something, I think that's a real conversation about whether the state is going to need to leverage a bit to put some money on the table to ensure that we don't turn what could be an eviction crisis into an even larger crisis for our rental housing market.
Yeah, and I think the landlords I've spoken to understand that even if they were to evict for some sort of non-payment scenario eventually, right, there may not be anybody to replace them with.
Right.
So I think the better scenario is to keep tenants in place who want to remain in place in their communities, but find some way to help them get the money back, where at least portions of it at least ultimately have to land at some point.
Yeah, and I think the other piece of that, I didn't mention this date, but March 1st is the time period when civil actions could commence against tenants who owe some portion of rent, right? Thankfully, that's later than this bill expires. I think that's going to be the other part of the question, because if the solution that's proffered in January is, well, you can file a small claims court action against all these tenants to try to get blood from a stone, I think that also is not a workable strategy. So I think that's another.
They can be garnished into the next generation. I mean, it's not a tenable situation for anybody. Well, thank you so much.
Yeah.
Oh, I had one more thing. 2045, the Burke bill. Do you see any chance? I'm seeing petitions going out trying to encourage signing of that, and if it were to get signed, do you see that it would have actual tangible impacts, or is it more aspirational?
I think it's an entry into that conversation about I think it's more the latter. I think it's a conversation starter, but we'll see. I mean, I think something similar was enacted with respect to the right to safe drinking water, which I think has been a launching point for other policies.
And back to one more question about the mortgage relief situation. The federal government was allowing landlords whose mortgages have switched over to a Fannie Mae, Freddie Mac backing to negotiate and tack payments onto the far end of their mortgage rather than the front end. Do we have any idea how many landlords have taken advantage of this incredibly generous offer, and if that is going to be extended?
Honestly, I don't know the answer to either of those questions. I have not seen anything on that. I'd be curious to find out.
Okay, thank you.
I have a question on the preemption provisions of AB 3888 with regard to local ordinances related to COVID. So I understand that jurisdictions like Santa Monica, our current ordinance is in effect, our eviction, emergency COVID eviction prevention ordinance is in effect through the end of September. And I understand that we can't extend its provisions related to non-payment of rent. But we also have provisions in our ordinance regarding, protecting folks for evictions based on nuisance that might be related to COVID, extra pets, extra family members. May we extend those, or are we preempted by AB 3088?
Our reading of the bill is that it allows the extension of those as long as they are not related to non-payment of rent for that protected time period.
Excellent. Thank you. Commissioner Trosis.
Brian, as always, thank you. Thank you for all of your work. I know that it was absolutely crazy this session. I'm curious, there's a few development-related bills, obviously, that did not pass. I think of most interest to me was Senator Atkins's SB 1120. I know it's like that might have had the votes. What do we think is coming back on the development side, and what should Santa Monica be prepared for? And then at the same time, how do you weave in like housing protections and renter protections to any sort of like economic relief package that may or may not be passed? I know all this is hard to say given that we have literally gotten no relief from the federal government, but I'd just be curious to know like what you think is going to happen related to some of these development measures.
I mean, I think the conversation around production, that these bills, I mean, compared to earlier iterations of this sort of policy of trying to encourage production, SB 50 chief among them, were far more far-reaching than even 1120, which really just, I think, it essentially comes down to doubling the number of units in a single-family zone potentially. I'm every expectation that conversation will continue, particularly given that the pro tem has made that a signature issue, and that a number of these bills which failed, some for procedural reasons, as you said, had the votes and had her support. So I suspect that she and others and the opponents of some of these measures are not done with that conversation. I think it's also true that the conversation on the other side is also equally ramped up around those who are opposing these measures. And so I suspect there will continue to be proposals and continue to be controversy around it. I think on the question of tenant protections, and I'm hearing in that question a bit sort of how do we also ensure that some of these measures don't drive gentrification and displacement. We have built, I think, a lot of really good models, policy models in some of the prior legislation, including those that didn't move forward. And I suspect that those will be the starting point for conversations around those same protections and any subsequent measures.
Good. Well, I hope that you, as our advocate, and Stephen, I know he's on the way out, but with this model language that we have around gentrification and anti-gentrification measures, very important to me, particularly as I feel like we're on the kind of brink of an eviction cliff, because even paying 25% of the rent is untenable for people who don't have a job and are not getting any sort of pandemic unemployment compensation, like supplemental unemployment compensation. So thank you for all that you're doing. I'm very, very concerned, and whatever we can contribute to in the new session around recovery and anti-gentrification, of course, we want to be front and center there. So thanks, Brian.
Thank you.
Agreed. Thank you.
Thank you all.
Okay, thanks so much.
Brian.
Brian. I believe our next administrative item will be a staff report from our general counsel. So welcome, Mr. Lewis, if you are here. Thank you.
I am here, yes. And I'll be relatively brief because this is really not a new item. As a part of the board's budgeting process earlier in the year, the board substantively already agreed to the things that are the subject matter of the two umbrella agreements that are attached to the staff report. One of those umbrella agreements relates to the provision of employee medical benefits, and the other relates to contributions to the employee pension fund, CalPERS. With respect first to the medical umbrella agreement, the substance of that umbrella agreement is that just as city employees, consistent with their agreement with the City Council, will from January 1 of 2021 pay 8% toward their medical insurance premiums, so will the board. In the past, those have been fully board paid, and then over recent years, employees have started to contribute small amounts, increasing incrementally over time. And now that increment is up to 8%, and that brings us into full conformity with what the rest of the city is doing as well. The second, before we leave the issue of the medical umbrella agreement, that in the actual agreement that is attached to the board packet, in paragraph 4, there's a reference to paragraph 5. It should be to paragraph 7 of the city's MOU. So there's a typographical error as to which paragraph is referenced. In the version that will be sent out for signature, that has been corrected. I just wanted to bring the board's attention to that in case anybody had been so diligently poring over it that you had noticed that typo. With respect to the umbrella agreement relating to contribution to CalPERS, up until recently, the city had been paying 1.23% on top of what is the 8% that employees contribute toward their own pensions. The city is no longer doing that. That there was a long negotiation between the City Council and the coalition of city employees, including miscellaneous municipal employees, which include board employees, to decide how to handle this going forward. And the resolution of that was that employees will continue to pay the 8% that they've always paid, but that will not be added on to in the amount of 1.23% by the city, or in this case by the board. So this umbrella agreement brings the board into compliance again with what the rest of the city is doing with respect to contribution to pension fund. And with that, the documents are before the board to approve. And upon approval, again, the board has already approved this substantively. They'll be executed by the representatives for the various bargaining units, as well as the chair, and it will be in place. The change with respect to the PERS issue has already taken place. That has been in effect since July 1.
I feel that this is pretty straightforward. Are you? I'm prepared to make a motion unless any other commissioner would like to speak on the item. Okay, I move to approve the documents before us and direct staff and the chair to sign them.
Second.
Can we take a vote?
Yes. Commissioner Drawn?
Yes.
Commissioner Foster?
Yes.
Commissioner Frosis?
Yes.
And Vice Chair Sultan?
Yes.
Motion carries.
Thank you for that. So I believe that may be the end of the business we have before us tonight, unless somebody disagrees. And therefore, we have reached adjournment. The next board meeting will be held on October 8th, 2020 at 7 p.m. It said venue TBD, but I'm assuming it will be here unless something radically changes. So I look forward to seeing everyone in about a month, same time, same place. Have a good night.
Oh,
We need to do some. Do we have to vote to adjourn?
Yeah.
Okay, excellent.
I move we adjourn.
A second.
May we have an official vote, please?
yes. Commissioner Duran,
Yes.
Commissioner Foster,
Yes.
Commissioner Trosis,
Yes.
and Vice Chair Sultan.
Yes.
Motion carries.
Great. Now I will say thank you. Look forward to seeing you all in a month. Take care.
Good night.
Good all.
Good
Bye.
Everyone.